Welcome back, everyone. We're here to finish off by going over 3 evidence essays and seeing if we could identify the issues and see how well we could do. I think this has been really effective, but I can't stress enough that everyone who's taking this course or who's watching this course to make sure that you're going over all the former essays and just really making sure that there's no essay that's ever been written and a model answer that you don't understand. I think that will lead to success. And what's up?
I think it's question 2.
Nice question too. And under Matt's suggestion, I had on the calendar, if everyone could see, just very quickly, the updated UBE calendar. We've done contracts, we've done torts, we've done property, we've done con law. Matt says con law is not very heavily tested. We did CivPro and evidence is what we're doing today. But if you see, I had at the end us doing back-to-back MEE. We're gonna switch one of these MEEs. And Matt, of all these subjects, which do you think is the least tested of agency partnerships, corps, LLCs, trust, wills, secure transactions, family law?
Yeah, family law.
Family law. All right, perfect. So we'll sub this Sunday, family law.
Agency are like, I mean, it's not guaranteed, but like those are the 2 like most commonly tested like essay topics on the essays.
Are CivPro and what?
Oh, like agency is probably like just as common as CivPro. Corporations just like a little bit less.
Oh, so next week is a super important week, everyone.
He's like, yeah, super commonly tested.
Super commonly tested. All right, excellent. So we're gonna switch family law with MEE to make sure that we address the MEE because MEE is guaranteed to be tested. And did you write 2 MEEs?
MPT, but yeah. ME is like the essays, MPT is like when they give you the stuff.
My bad, I keep confusing them. Sorry about that. MPT. We'll do the 2 MPTs.
What did you ask me about that?
It's you have to write 2 essays, right, for the UB?
Yeah, they give you hours. You have to write 2. You have to like, which means like you have to like make sure you're timing yourself. Like once you're at like an hour 30, like that's when you should start like wrapping up if you're not done.
All right, excellent. So we'll move the MPTs up. I'm sorry, everyone. We're gonna do 2 MPT courses, and we're gonna switch family law with MPT, so we get one of those MPTs earlier at Matt's suggestion. But without further ado, let's look at this question. And what's the call of the questions? Evidence. Should the judge allow the bartender to testify about what he overheard the owner saying on the phone? Explain. Should the judge allow the bartender to testify about what he overheard the waiter saying to the owner? Explain. Should the judge admit the certified arson investigation report in light of the owner's hearsay objection? Explain. And the owner's constitutional objection, assuming the hearsay objection is overruled? Explain. So it seems like con law kind of gets sprinkled into other subjects. Like maybe if it's not tested in its own, there's
no,
like,
I mean, it is just like rarely.
Right, but this is the second time I've seen like just the constitutional consideration of another
I
subject.
think that might honestly be a coincidence, but maybe it's not.
You're right. All right. And I'm super sorry. MEE is all the subjects. MPT is a performance test, obviously. All right. On July 1st, a restaurant owner was arrested and charged with arson after June 1 fire destroyed his failing restaurant. The prosecutor plans to call a bartender to testify at trial. The bartender had worked at the owner's restaurant and is expected to testify as follows. The owner followed me at the beginning of May, a few weeks before the fire. On April 23rd, before I was fired, I showed up at the restaurant a little early for my shift. The owner was talking on the phone when I arrived. As I walked in, I heard him say, "I know it's risky, but I'll do whatever it takes to get some money back from this lousy restaurant." When I came to the restaurant after I was fired to pick up my final paycheck, I overheard one of the waiters telling the owner, "Count me in on your plan to burn down the restaurant. I've recently done that sort of thing and I haven't been caught." Does anyone have any ideas what this implicates already?
Yeah, this is just screaming stuff from the questionnaire.
Just his ability to say he knows this person's voice, authentication.
Interesting, yeah. I just realized that Paul was quoting Ricky Bobby. He's not actually flying through the air. And now, yeah, we're
15 years. Yeah.
Shake and bake. And then Brighton is saying party opponent. I like that. Party opponent mission.
But also mimic, if anyone like might know where that is in here.
and also mimic, which is
Yes.
motive, intent, mistake or lack of mistake, identity,
Scheme.
common scheme or plan. He started saying scheme. What were you thinking, Matt?
Yeah, like, what is that? Like motive, not motive, like skill or lack of mistake, not lack of mistake, like knowledge of how to burn down a restaurant, probably.
Yeah.
Also, like we haven't read the full prompt, so like sometimes like you see something and we're like, oh, that's obviously this. They don't.
course. And something that I saw is not only we said party opponent mission, but also the employee, right? Because the relationship, the employee of the party opponent, right?
Mhm.
Okay. The prosecutor also plans to introduce a written certified report prepared by a police arson investigator on August 1st. The arson investigation report states, this arson investigation report was prepared to assist in determining the cause of the June 1st restaurant fire and in developing evidence relevant to the pending prosecution of the owner for arson. Pursuant to investigation of the interior and exterior of the premises, I've concluded that the fire began inside the restaurant where I detected the presence of fire accelerants. The possibilities of a naturally occurring or accidental fire, electrical fire or gas fire have each been eliminated using a range of tests and reconstructions. Based on my data, I conclude that the fire did not occur accidentally and that the use of fire accelerants inside the structure caused the fire to spread quickly and increase the extent of the damage. The bartender is available to testify, but the waiter is unavailable because he fled overseas after learning that he was under the investigation for arson, and the court cannot compel him to attend. The arson investigator is unavailable to testify at trial because he has died, but the prosecutor plans to introduce the arson investigation report through the testimony of an expert witness, an out-of-state arson investigator who did not participate in the arson investigation. The jurisdiction's rules of evidence are identical to the FRE, and the defendants no greater rights than those mandated by the federal constitution. The owners objected to all proffered evidence mentioned above on the grounds of hearsay. The owners also raised a constitutional objection to the introduction of the arson investigation report. It's pretty solid, right? So we have some parties, right? We have a bartender who's saying that that the waiter told the owner. So we have a bartender saying the owner made a statement. We have the bartender saying that the waiter told the owner a statement. So maybe that's a hearsay within hearsay potentially, just a kind of considerations, multiple statements. And then we have a written report by an arson investigator, and he says all these things. And then we find out that the bartender is available, the waiter is unavailable. What about the owner? The bartender is available, the waiter is unavailable. They don't talk about the owner. I guess that's not being mentioned. And the investigator is unavailable because he's died. So the waiter's unavailable because he fled. Investigator's unavailable because he died. And he plans to introduce the arson report through the testimony of an expert witness who he didn't participate, but he seems to be qualified.
Yeah.
All right. Tough question. I think evidence is tough, especially because, Florida, which I'm used to teaching, doesn't test evidence as an essay subject. So I'm definitely going to learn a lot here, Matt, and lean on you. Should the judge allow the bartender to testify about what he overheard the owner saying on the phone? What does anyone think out there?
I would
Yes.
say yeah.
Why do you guys say yes?
Because he can give his impression on what he heard, because he knows the owner's voice and can authenticate that, yes, that is his voice. And it's the topic's on the tip of my tongue and I can't say it. But
So
I know
you're saying he has personal knowledge of the conversation.
yes. And
Yeah, I agree with that. That's the first thing. It's definitely, is it relevant? Does it have personal knowledge and all that? I think the next question, right, is it hearsay or not? Is it what he heard?
Well, I think, like, what I was taught to do, I go relevance. Okay, it's relevant. Is it prejudicial? Okay, is it hearsay? Are there any other issues? But yeah, is obviously the main one. But I think they do want you to touch on relevance, and like everything's almost always irrelevant.
Is it relevant? Is it presidential? Is it hearsay? Is it anything else? I love that. So here, is it relevant? Certainly relevant. It's like about the arson.
Yeah.
Is
Does
it
it does it make it more or less probative? Obviously.
obviously? Is it prejudicial? I mean, it doesn't seem like it. He's just saying his piece. Is it
I mean, maybe like maybe you could argue like there's some prejudice, like he's it accuses him of hating his own restaurant and like not making any money and being a bad businessman. But like, is it substantially prejudicial? Does it substantially outweigh the probative value? No.
well, and there's no evidence from what I see that the bartender has any bias, right? He's just a bartender.
Yeah.
He just doesn't seem like there's no evidence here that he loves or hates the owner of the restaurant. He just seems to be a bartender. Okay. And now the hearsay is definitely the matter of concern. Does everyone seem to agree that we have to do a hearsay analysis here? Because it's an out of court statement, right? What out of court statement proffered into evidence in order to prove the truth of the matter asserted, right?
Yeah, kind of like a double hearsay where you're trying to say, count me in on your plan. So you're kind of implying that.
Well, wait, we're not even there yet. It's just the first one, which is just
Right.
right. It's just the owner, not about what the waiter said to the owner. So I think this is just hearsay. I think the second one's hearsay within hearsay, right? Yeah. So this first one just hearsay. So what he said on the phone, he heard him on the phone say, "I know it's risky, but I'll do whatever it takes to get some money back from this lousy restaurant." What do we think that is? A hearsay exception potentially?
Yeah, that is I was not party opponent. I'm thinking
motive.
I don't want to say effects on the listener. It's on the tip of my tongue, but I do know it's because it's a hearsay exception because of the statement being said.
Okay. So we think it's a hearsay exception because it's not being brought in for the truth of the matter asserted, is what you're saying? It's being brought in for some other reason.
Yes.
So that he had knowledge, or he wanted to get money back, or like, what
Present sense impression.
Present sense impression. Okay. What are the thoughts there?
Yeah. Did we say party opponent?
Yeah, party opponent is a good one, right? That it's an admission. I'll do whatever it takes to get some money back from this lousy restaurant. The other thing I liked what you were saying is, well, you're talking about mimic, which is usually for prior bad acts, but it could also be, to show something other than the truth of the matter asserted. Not to show that he did it, but that he had a motive, right? That we're not bringing it to show in that like he'll do whatever it takes. We're bringing it to show that, some effect on the listener or something like that. Like
motive, well, like this is showing that he lacks money.
Exactly, that he lacks money. So we think
But I think Paul might have written in the chat, I can't find it now, but
state of mind.
exception.
He wrote state of mind or motive, right? And his exception that goes to state of mind or motive.
I think like, when it's hearsay, it's not like technically mimic, it's like considered that state of mind exception, but it's all the same.
Right, the state of mind exception that he'll do whatever it takes. That's how he felt in that moment.
Yeah.
And it's probably admissible as a hearsay exception. Okay. What about the second piece? Should the judge allow the bartender to testify about what he overheard the waiter saying to the owner? So I do think this brings up hearsay within hearsay, right? Or no, not really. When I came to the restaurant, I overheard one of the waiters telling the owner. So I guess not, yeah. No, not really hearsay within hearsay. It's just hearsay, what he heard. I heard the waiter tell the owner, count me in on your plan to burn down the restaurant. I've done that sort of thing and haven't been caught. We identified this as, well, is he available? Remember?
Right. So then that would be, since he's not available, Andrew, because he fled, then that's this, you can try to get this in as a statement against interest.
Exactly. And how do we know it's a statement against interest and not a party opponent admission?
Because a party opponent admission Well, you could try as a co-conspirator and see if there's a conspiracy there, but you have to be available, I believe.
I agree with you that a party opponent mission is for when the person is available. The statement against interest is when they're unavailable. And here the facts clearly state that they're unavailable, right?
I actually think it could be a party, like admission by a party's employee or their.
That's true.
If the owner is available, maybe.
Yeah, I mean, I think employee would fail because like talking about burning down the restaurant isn't within the scope of being a waiter. But I think you probably could do it as like statement of a co-conspirator.
Interest, looking at potentially statement as a co-conspirator. We're looking as a party opponent mission as an employee, but you're saying it's outside the scope of
Yeah.
business.
The fact that it's unavailable will come into the confrontation clause part, but like we're not there yet.
Right. I thought statement against interest because they're unavailable, and that's the differentiation between unavailable and between statements against interest and party opponent mission. Regardless, we'll continue and see what the correct answer is in learning. Should the judge admit the certified arson investigation report in light of the owner's hearsay objection? So what's the hearsay objection?
Look at the arson report.
The arson report.
Yeah.
I mean, it says straight up that they're using it for the purposes of determining.
Yeah, so this is a public record.
I like public record, yeah.
Hey guys, this is the part of evidence that always gets me, even on a multiple choice, when we're talking about reports and cops making the reports, because in my head I'm thinking, well, is this I probably get it wrong a lot because I'm always thinking, well, it's not a court document per se that I can use to call somebody a liar, to call somebody into question. So that the reports, I'm still having trouble with police reports because thank you, Paul.
Police reports are the purpose of trial, so it's inadmissible. So
Yeah, I think that's getting
the
into
police reports are generally inadmissible, but there is a public report that are generally admissible.
there's an exception to the public records hearsay, which is that like reports made by law enforcement can't be used against criminal defense. Let me find that exact language.
Right.
Yeah, public record, a record or statement of a public office if a matter observed while under a legal duty to report, but not including in a criminal case, a matter observed by law enforcement personnel. I would assume an arson investigator is some kind of detective and not a private like contractor.
Because these are the type of, even on multiple choice questions, these are the type of questions that I see over and over again when they talk about police report. And the cop's not here to testify, so you have to get the police report.
All right. So what do we think? Should the judge admit the certified arson investigation? What are your thoughts?
I would say no.
No, it should not be admitted.
I mean, I'm sure there's like maybe it can be admitted under a different hearsay.
But you're
There's
saying
just like so. I mean, it can be maybe it can be admitted under a different hearsay exception. I just can't think of it right now.
but as a
As a record, I would say no.
no, because it's more or less a police report, and like as Paul was saying, they're usually inadmissible police reports. They're for the trial, not for proving the case. It was prepared to assist in determining the cause of the fire, right? Maybe a business record.
Yeah, I think I was thinking that, but I don't see anything about like regularity.
Right, I would still mention business record.
Yeah, I would.
Right, yes, as a public record exception, right? If it's a fire administration, so there's definitely, we know it's a public record exception argument. I'm not 100% sure if it's going to be admissible or not under that exception.
Like there's just so many
And the
exceptions.
exceptions. Yeah. What about the constitutional objection?
So that would be a confrontation clause, which I think people have been like kind of asking about.
So as long as that was quick for you to see, maybe not everyone else in the class, including myself. When they said constitutional objection, it would mean confrontation clause because the person's dead, right? The arson investigator is dead, and they want to bring it through the testimony of an expert witness, but he did not participate in the investigation, so there's no opportunity to confront him. I do have a problem with that. Like, how come you can't confront the person who
Yeah.
completed the report?
So I would think that it's not testimonial, because I think arson reports generally are not prepared.
Right.
They're prepared to like survey what the damage was. But can you scroll up? Because let's see what they say about it.
Did not participate in the arson investigation. I think that's crucial to it being non-testimonial. I like what you're saying there, because
Can you
it
scroll up?
wasn't in the purpose of this particular litigation. It was just made as part of his job. Like, that's what he does.
Yeah, but I think that statement's talking about a separate person. Could you scroll up a little bit more? Yeah. Police arson investigator. I mean, but it says the arson investigation report was prepared to assist in determining the cause of the restaurant fire and in developing evidence relevant to the pending prosecution of the owner for arson. And it's also a police arson investigator. So I would say confrontation clause would mean it cannot be admitted because he's not available to testify.
Right. This is an out-of-state investigator. So the issues are, we don't have the right to confront the out-of-state investigator. So that's a confrontation clause issue. And the issue of hearsay is
The out-of-state investigator was going to be an expert witness who would testify to the report, but the person who made the report is dead. And the fact that you can't confront the person who made the report is a confrontation clause violation.
right. They're both. Ideally, we want to confront them both, especially the person who made the statement. And I would like to confront the expert witness. I don't know which one's going to be the problem. I think the fact that the person who's dead who made the statement, and then here it was prepared to assist in determining the cause of the fire. It sounds like hearsay to me. It really does sound like hearsay to me. The confrontation clause issue, I'm not so sure about, to be honest. What do you think? Do you think that an objection, should it be admitted despite the confrontation?
Not because of the confrontation clause.
You think that it fails the confrontation clause? It fails to adhere to the confrontation clause. Anyone out there agree or disagree with that?
When he says it fails, meaning like it can't come in because he can't confront him.
Yeah.
Exactly. That's what we-
Okay.
Do you agree with that, or thoughts towards that? They're trying to infer that as unbiased as an out-of-court report. That's what Paul's asking. That is biased. Yeah, they're trying to infer that that it could be unbiased as an out-of-state report.
Oh, I think out of state, I think people are just reading too much. Yeah, I think that's what like the implication is, that he's just like some guy who doesn't have any bias or like.
Right, that's the implication. All right, well, so we have the questions. Should they let us bring the first one in because of what he said on the phone? And we said maybe it's not being brought in for the truth of the matter asserted. Maybe it's a statement, it's a party opponent admission. What do you overhear about the waiter saying? We're saying maybe that's a statement against interest, or we were also saying that maybe it's a present sense impression, or like an exception to hearsay. And then for the last one, is it hearsay? We were saying it probably is hearsay because it doesn't fall under the public records exception. But maybe it will be admitted. And then the constitutional objection we think is strong, that there was no opportunity to confront the witness because they died.
Yeah.
I'm sure we touched on a lot of key points, but this is tough things, and I'm glad that everyone's here learning, and we're all learning together.
So an important thing for the confrontation clause that I didn't talk about before is that if you kill the person to stop them from testifying, you waive the confrontation clause, right? You can't say, oh, the confrontation clause, it can't be admitted because they won't testify when you killed them. So they wouldn't testify. So that's an exception.
Right, if you kill someone, then obviously you can't take shelter into that. Okay. The issue is whether the bartender's testimony about the owner's statement constitutes a party opponent statement or a statement of mine exception to hearsay rules. Excellent. Good job, class. We're right on top of it. Evidence is relevant when it makes a fact of consequence more or less probable without its presence. Hearsay statement is an out-of-court statement offered to prove the truth of the matter asserted and generally barred from admission unless the statement falls under the several exceptions. A statement by a party opponent when offered by an opposing party is considered to be non-hearsay and admissible. A statement of mind exception to the general hearsay prohibition allows statements which show a present intent or plan to do something in conformity with such intent. Even when a piece of evidence is relevant and otherwise admissible, if the probative value is substantially outweighed by the prejudice, then the evidence is not admissible. Here, the bartender's testimony regarding the owner's statement is clearly relevant as it relates to the potential cause of fire, which is a subject matter of the prosecution. This is exactly what Matt instructed us to do. Go through the first, factors. And the testimony is a hearsay statement because it's out of court statement offered to prove the truth of the matter asserted, which is that the owner planned to burn down the restaurant. However, it's both a party opponent statement, which is non-hearsay statement, and a state of mind exception to hearsay rule. Because it was made, so they're saying it was both things that we argued. Because it was made by the defendant, offered by the prosecution, the testimony is a party opponent statement. Also, because the statement shows the mind of the owner at the time, which is the intent and plan to burn down the restaurant, and his conduct in conformity with the intent, this statement is admissible as a state of mind exception to hearsay rules. Lastly, if it is true that the owner had made such a statement, the probative value is substantially larger than any potential prejudice to the owner, and therefore the admission is not barred for that reason. Therefore, the bartender's testimony is admissible. We were so on top of this. It was both things we argued separately both were true. Was that it was a present, it was a statement of mind, right? Statement of mind, present state of mind exception, present state of mind exception, and a party opponent admission. Anyone have any questions about why it was those two things? All right.
No, my only question is, like, my whole thing is with the essay is formatting, how I'm going to format it, how I'm going to think about it, what's my analysis going to be from top to bottom. And this one, like when I say, which is a non-hearsay, it's like how I'm going to be able to state the rule like that without causing myself to reach a conundrum where I'm like, oh crap, I'm just rule dumping. Because it just seems like this is so conversational that they're not really rule stating, but you're just telling you what exception or rule applies.
Yeah, I would disagree because look, it's only 3 paragraphs long, but they did the IRAC. The issue is this, right? Whether it is a party opponent statement or a statement of mind exception to hearsay. That was a great job. The rule is this. Here is when evidence is relevant. Here is when evidence is hearsay. Here is when it's a party opponent admission. Here is when it's a statement of mind, right? And then here's just one other extra piece of the rule, right? Then, so they did the I, they did the R's, and it was just back to back to back to back to back to back to back. And then they did the A, the analysis. It's clearly relevant. It's hearsay because it's not a court statement. It constitutes both of these things. This is why it constitutes party opponent admission, and this is why it constitutes statement of mind. Lastly, it has to be probative, and it indeed is. Therefore, it's admissible. I think this is a classic IRAC issue, rules, analysis, conclusion. They didn't waste any time talking about irrelevant things, and they got all the points possible. So I know it seems like it's not, it's just rule dumping, but remember the analysis, each rule was attached to a fact, and that's what analysis is. All right, let's look at the second point. The issue is whether the bartender's testimony about the waiter's statement constitutes a state of mind exception or statement against interest exception. Again, we are on top of this. I'm very proud of us. Evidence is relevant when it makes a fact of consequence more or less probable without its presence. Hearsay statement is an out-of-state court statement offered to prove the truth of the matter asserted and generally barred from admission unless the statement falls under several exceptions. A statement by a party opponent, when offered by an opposing party, is considered to be non-hearsay and admissible. A statement of mind exception to the general hearsay prohibition allows statements which show a present intent or plan to do something in conformity with such intent. A statement against interest exception applies to an unavailable witness who made a statement which is against his interest, and a reasonable person would not have made such statement unless it was true. Even when a piece of evidence is relevant, otherwise admissible, if the probative value is substantially outweighed by the prejudice, then the evidence is not admissible. Here, the statement would be hearsay as it's an out-of-court statement offered to prove the truth that they conspired to commit arson. However, the statement qualifies under the state of mind exception as it clearly shows. You see how they're doing the analysis. They're doing it quickly, but they're doing it. However, the statement qualifies under stated by exception as it clearly shows the waiter's intent to commit the act in conformity with the stated intent, and the statement is clearly against the interest of the person, especially what he said. Lastly, because the probative value is not substantially outweighed, the admission is not barred. Therefore, it can be admitted.
I think it's interesting that they use the word conspiring, but they don't mention the co-conspirator.
Yeah, we'll look at the second model answer, maybe they do. And then finally, 3A. Evidence, the issue is whether the certified arson investigation report constitutes a business record exception. We said it maybe is business record. Evidence is relevant when it makes a fact of consequence more or less probable without its presence.
Probably wouldn't be repeating that like this person does.
Yeah, hearsay statement is an accurate statement, blah, blah. Public records, here's a new rule, which include not only factual observations, but also conclusions prepared by an officer as part of a public agency duty with knowledge of the subject matter at or near the time of the event are one such exception to hearsay rules. However, great job, Paul, public records exception does not apply to a police investigation report in a criminal proceeding against a criminal defendant, right? Serge, does not apply to a police investigation report in a criminal proceeding against a criminal defendant.
Yeah, that's worth writing down.
Thank you.
Yeah, that's very important. Business records are of another type of exception to hearsay rule. So Matt and I were discussing, is this business records or is this public records? And we're like, again, we would argue both, you know? It's all about identifying the issue and then just doing the IRAC. Business records are another type of exception when the records prepared as part of the organization's routine practice of business by someone under the duty to report and has personal knowledge at or near the time of event, accurately prepared and certified. Even when a piece of evidence is relevant, otherwise admissible, if the probative value is substantially outweighed by the prejudice, then the evidence is not admissible. And here's the analysis. Here, the police investigation report is a hearsay statement as an out-of-court statement offered to prove truth of the matter. Also is prepared as part of the agency's duty by someone under duty to report with personal knowledge at or near the time of the event could have qualified as a public record exception. However, because it's a criminal proceeding, Paul, on top of this, and the evidence is offered against the defendant, it cannot be admitted. However, and we argued this, but we weren't, so confident, the record can alternatively admit under the business record exception because it was prepared as part of the agency's ordinary business by someone under duty with personal knowledge. Also, there's no evidence as incorrect and certified. Lastly, the report's probative value is substantially not outweighed. Therefore, it can be admitted under the business record exception. So we identified both of these. We weren't really too sure, but we were pretty sure that it wasn't a police record. And then we said, what about a business record? And ended up being a good argument.
I think the business record one is a little weak here just because there's not that much evidence for it. But yeah, I don't think it hurts to mention.
What Paul mentioned in the chat and what Matt, I think, already stated is beautiful. It seems like for evidence essays, you want to talk about relevance, prejudice, hearsay, exceptions as the rules go. Then describe whatever specific hearsay exception applies to the facts. That's exactly correct.
You have to look at the call and if they're only asking about witness bias or jury misconduct or something, then you're not going to talk about relevance.
Right. The issue is whether the testimony by the expert will be barred from the confrontation clause. Confrontation clause prevents evidence from being admitted against a criminal defendant when the evidence is testimonial hearsay, the declarant is not available to testify at trial, and the party against whom the evidence is offered did not have an opportunity to cross-examine the declarant. I would write that down too. Confrontation clause prevents evidence from being admitted against a criminal defendant when the evidence is testimonial hearsay, the declarant is not available to testify, and the party against whom the evidence is offered did not have an opportunity to cross-examine the declarant. A statement is testimonial when its principal purpose is to support the prosecution of a crime by ascertaining criminal conduct. A party is considered unavailable when they died and thus cannot attend the proceeding. However, when a privy attends a proceeding, it may be considered an opportunity to cross-examine. Here, the investigation reports are testimonial because its purpose is to assist the prosecution by ascertaining criminal conduct. Also, the investigator already had died before the proceeding. He is considered to be available.
That assuming means unavailable.
Unavailable, yeah. Lastly, even though another expert will be testifying on behalf of the investigator, as he did not participate in the investigation, it's difficult to see that he's available for the proceeding or the defendant with the opportunity to properly cross-examine. Lastly, because he said lastly already. How many last is he gonna have? Lastly, again, because the report is objective investigation prior prosecution, its probative value is not substantially outweighed by the
This part is wrong because that part is not. That's not even part of the confrontation clause analysis.
Therefore, the report cannot be admitted because it's a violation. I mean, that part is right.
Yeah.
But let's see the another person, right? So It's got to be relevant. It's got to be all these things. This one was much quicker. Here, there's no confrontation about a suit because the claim is itself.
To pad it out.
Because it's not hearsay. A relevant privilege. Testimony the owner knows something is risky. And for relevant statement exclude if they are hearsay. Party opponent, right? Statements by a party opponent. The owner's statement over the phone is thus admissible as a party opponent. Okay. Testimonial, we said that he's unavailable, and they argued that it's most likely statement against interest, right? As we said, or maybe it could be present state of mind. And then here for the public record, they're talking about being business public records or a business record and be admissible. And then here, I want to see what they say here. Non-testimonial, they had prior opportunity. And he's unavailable. The reporter's testimonial is made in emergency circumstances. And that did not indicate they had a previous opportunity. He should admit the report. He should not admit it. Note that the prosecution plans to admit this evidence to an expert witness, while the expert, so long as he is qualified, may rely on therein, may be able to rely on statements contained therein to form his own opinion. However, the certified arson investigation report is still not admissible in the Sixth Amendment. So
Yeah, I think the last paragraph was unnecessary, but yeah.
yeah, a lot of unnecessariness. Let's do one more. I know we planned on doing 3 today, but let's
Great.
just do one more because I know we have a lot of brain frying going on out there. And I think, you know, the evidence ones, that was a good one. It really was about hearsay and what we may see. So we'll do one more and then we'll call it a night. And we'll send everyone an email tomorrow, which will have your assignments. And honestly, I think we're going to do 2 civil procedure essays, and we might even do 2 evidence essays.
So we
So
just do more and more, and then like make the one that we don't do the assigned essay.
that's exactly what we're gonna do.
Hey guys, quick question. Can we add a little spoke to it, like for like analysis purposes? Like for me, the whole thing is structure. How do I structure? Because it helps me even when I do multiple choice. How do I structure? How do I think about it? Because like we just did that, and I'm like, okay, that's this, okay. But then I'm like, how do I analyze it?
Well, you really have to sharpen the skill of modeling the model answers and replicating the model answers and ascertaining from the model answers. So the reason why we just go over the model answers and we go over both of them is because that's a really good way to structure it. And you see, they all do IRACs. They say what the issue is, they name drop the rule, and then they attach the rule to the relevant facts, and then they come up with a conclusion. So it's structure is important, but it's really more about identifying the issues and then doing a proper analysis. Let's see, we're doing question 5 right here. Matt, do you have anything to add about that, to structure?
I don't. What I did is I looked at what these people did and I kind of modeled that.
Right. Yeah. I think we just want to model off their structure, but it's simple. It's 2 to 3 paragraphs for most. It's identifying the issues, dropping the rules, and doing an analysis that really here the facts show this, which is related to this rule, period. And that's just kind of it's a search and match. So, okay. Is the mechanic's testimony admissible? Explain. Is the invoice for the new parts for the woman's truck brakes admissible? Explain. Is the doctor's testimony admissible? Explain. And is the roommate's testimony admissible? Explain. So we got mechanic, an invoice, doctor's testimony, and roommate's testimony. We see all about admissibility, probably hearsay. A woman has sued a man for injuries she received in an automobile collision at a suburban traffic circle in State A on January 1st. Both drivers were driving alone. There were no other witnesses, and a forensic accident investigation failed to determine which of the two drivers was at fault, which of the two. Among other things, the woman's complaint alleges the following. The woman was driving her pickup truck in the traffic circle at or below the speed limit when the man suddenly pulled his car into the traffic circle immediately in front of her. The man's action left the woman no opportunity to slow down, stop, or avoid colliding with his car. The woman observed that the man was texting on his phone when he entered the traffic circle and did not see him look up to check for traffic before entering the circle. The accident caused the onset of significant neck pain for the woman, requiring extensive medical treatment and resulting in lost wages. The man has denied that he was texting at the time of the accident and alleges that the accident was the woman's fault. According to the man, the woman was driving her truck substantially over the speed limit, her brakes were defective, and despite the fact that the man's car was far ahead of the woman's truck when he entered the traffic circle, the woman failed to slow down to avoid a collision. A jury trial has been scheduled. The man's attorney plans to offer the following evidence. Testimony by a mechanic to the effect that I inspected the woman's truck a week before the accident. The brakes on the truck were worn and in need of repair. I ordered new parts. What do we think about that? Let's just do this piece by piece and then we'll read the answer.
Expert witness.
A mechanic. I don't think he's an expert necessarily.
I think he'd be a lay witness.
Lay witness.
Like, this is one of those cases where it can kind of fuse together.
I think he's just saying his, like, what he observed, like maybe his present sense impression, maybe some personal knowledge.
And is it hearsay? I mean,
He's testifying, so it wouldn't be even be hearsay in the first place.
He says, I inspected the woman's truck a week before the accident. The brakes on the truck were worn and in need of repair. I ordered new parts. So it's like saying, like, you know, it's kind of, I was thinking my cousin Vinny.
right, but My Cousin Vinny is a show where like there's a woman on trial and that's a movie about her maybe being an expert, maybe not. In reality, this mechanic, there's nothing here to prove that he's an expert. An expert has to be qualified first. It would say this mechanic who's qualified as an expert by la 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 la, but we have to assume lay witness unless they tell us why they would be qualified. Go ahead, Matt.
Oh, I mean, I would think the fact that he's a mechanic, but I think you should like recognize that like the fact pattern doesn't say much.
Yeah, okay. So do we think this is admissible?
Yes.
First of all, it's not even hearsay because he's testifying.
Okay.
So I think the only issue is like, well, like the brakes on the truck were worn and in need of repair. That's an expert opinion. So I think the issue is he an expert?
Okay. Yeah, right. Has he been qualified? So yeah, that's what
That's something a lay witness would say. The brakes on the truck needed repair. That's something an expert witness would say. I ordered new parts. That's something a lay witness would say.
and it's important. Sergio's getting to that is he been qualified as an expert? He sounds pretty lay to me, but he's trying to say things that an expert might say. But maybe, yeah, there's an argument there. It seems that he has personal knowledge, and you don't need to be an expert witness to say that they were more in need of repair because that's what he does. All right, let's look at the second thing. A written invoice signed by the mechanic stating new parts for the woman's truck brakes ordered on December 23rd and received on January 2nd, found in the mechanic's file cabinet among similar invoices for other customers. So written invoice signed by the mechanic stating new parts for the woman's truck brakes ordered on December 23rd and received on January 2nd, found in the mechanic's file cabinet among similar invoices for other customers. Does that sound admissible?
Yes, but I think we really need that invoice though. Like I think that maybe there's best evidence going on.
But they are bringing in the invoice, yeah. Yeah, I think that's a business record. I agree, Paul.
Yeah.
That seems like a business record, and we're going to bring it in. I would argue.
There's like a big thing here that's a hint that it would be satisfied as a business record.
Similar invoices.
Yeah, exactly.
Similar invoices.
Which means that he this isn't a one-time thing. Like he does this regularly.
Do this. All right. Testimony by the woman's doctor who treated the woman for neck pain after the accident that the woman told the doctor, I have suffered from painful arthritis in my neck for the past 5 years.
Yeah. Statements for purposes of treatment.
Yep, medical records. Looking like a lot of stuff is coming in. The woman's attorney plans to
Say within here, say like the statement itself would be medical record, or actually, I wouldn't. It would. I think this would just be. Well, I guess we'll have to look at the question. I think this would just be party opponent because the doctor is testifying, so that part wouldn't even be hearsay. But we'll see.
testimony by the woman's doctor who treated the woman for neck pain after the accident that the woman told the doctor, I have suffered from painful arthritis in my neck for the past 5 years. The key thing is who treated them for neck pain. So it depends. Was this statement made in for medical purposes for retrieving treatment? It's probably admissible. Matt saying that they're a party to the case and that has relevance. I agree. The woman's attorney plans to call the man's roommate to testify that the man is addicted to texting and never puts his phone down. He even texts while driving.
Ooh.
Habit.
Habit for addicted to texting and never put his phone down. I kind of think, right? He even texts while driving. Well, is that being brought into shown that he was texting while driving, or being shown that it's a habit of doing that?
That's so prejudicial.
Very prejudicial. I agree. There's something prejudicial to this. And he's the man's roommate. Does he have any bias here?
Yeah, I mean, I guess
Okay.
there's not enough facts to indicate either way.
Okay. State has adopted identical rules of federal rules of evidence. So it's all about admissibility. So Serge was asking about this, and we'll end class by talking about this, and then we'll read the model answers. But structure. So Serge, do you have trepidations about how you would structure your responses here?
I have trepidations about how I structure a lot of responses, but yeah, because I would have to think about the relevancy of
July
what's
2018.
the order in which I would go. Do I go relevancy? Do I go this? Do I go that? Because once I know how I'm going to think, it makes it easier for me to insert.
So Matt, you had a structure for us for answering these questions. Is something admissible? What's your structure for just basically, you're presented with a piece of evidence and the question is it admissible? What's your structure for answering that question?
The first part, like,
Yeah.
so the issue is whether the mechanic's testimony is admissible. The testimony is admissible if it's relevant, not prejudicial, not hearsay. And for testimony, the witness has to be a lay or expert witness. Other rules for lay expert witnesses are blah, 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 blah. Okay, go into analysis. These are the facts. These facts intertwine with these rules. Then conclusion, the mechanic's testimony is or is not admissible.
Simple. I really agree, Serge. Like, that's how you would do it. It always has to be, relevant and, conform with the balancing test and not be prejudicial, and has to be probative, and then it has to be non-hearsay. And then here, an additional rule that we consider is the expert witness. But for these admissibility, you seem to always consider, is it relevant? Is it probative? And is the probative value not outweighed by the prejudicial value? And you got to do those things. And then you consider hearsay and then any other factor. So there's 3 factors you always consider: relevance, balancing test, and whether it's hearsay. And then you see if there's anything else, confrontation clause or privilege, or here we're looking at expert witness or something like that. Did that help, Serge?
Yes, because when I write my notes, I like to write them out like I would write an essay.
All right, bet. So let's go through this. I mean, we said, is the mechanic's testimony admissible? We thought probably because we had personal knowledge. Is the invoice admissible? We said probably as a business record. We said, is the doctor's testimony admissible? We said there's a strong argument for it being a medical record for the purposes of medical diagnosis. And is the roommate's testimony admissible? We said that there's an argument for habit, but there's also an argument that it's pretty prejudicial, and that maybe prior bad acts, but it's I don't love it. Let's see how they go through this, and we'll call it a night. And remember, the good thing about this course is there's a lot of time and we can stick to review, and Matt and I are available. Everyone in here should be in the UBE Telegram chat. It just seems to be me and Brighton talking to each other in there. But be in the chat, be checking your email, be submitting your essays, and we'll get through this together. So let's take a moment to look at what was it? Question
5.
2?
5.
Yeah.
All right, number 5. So the first issue is whether the mechanic's testimony is admissible. Evidence is look, this looks like it was written by Matt. Evidence is generally admissible for any issue for which it is relevant. Relevance means a tendency to make a fact more or less likely to be true. Relevant evidence is admissible unless its probative value is substantially outweighed by its prejudicial effect, or if it's cumulative or tends to confuse a jury. A lay witness can testify to relevant evidence based on personal knowledge or opinion, as long as within what an untrained person could reasonably know based on past experiences, and the opinion or observation does not require any scientific expertise or technical knowledge. A witness can be qualified as an expert witness in his or her field as long as the witness has adequate training, experience, and expertise in the subject. See, they're just giving the rules for the issues we mentioned. Expert evidence is admissible under the Daubert factors. So federal is using Daubert.
Yeah, federal, not Fry.
All right, solid, good to know. Which includes testable methods and standards and publication in journals generally recognized in the field. Here, and now they do analysis. Here, the mechanic's testimony is relevant and quite probative for the issue of whether the woman's brakes were defective. The mechanic testified based on personal knowledge that he inspected the truck a week before the accident. The opinion that the brakes were worn was probably an expert opinion, but because it required a level of expertise in auto parts. However, a mechanic would be expected to rely on widely accepted principles for determining whether brakes were worn, which are readily testable, print in relevant literature, and accepted in the field. The mechanic would have to be qualified as an expert to give that opinion, but assuming he is a professionally certified mechanic, the court should allow it because of his training, expertise, and experience in the maintenance of cars. Thus, the mechanic's testimony is admissible.
Like, I don't think mechanics are reading like peer-reviewed mechanic scientific articles. I think they're just like, they have work experience, but and like they rely on principles like from what they're trained. I think there's no like scientific journals that they're like, yeah.
Right. So we said personal knowledge is probably good, but that they were worn was probably an expert opinion, and he would have to be qualified as an expert opinion, and that's where the argument comes into play. So
Yeah, I just
we
think
were right on top of that.
It's a funny line.
The next issue is whether the invoice for brakes is admissible. Hearsay is a statement made by a declarant out of court that is sought to be admitted for its truth. Hearsay is generally admissible, but one subject, there's a number of exceptions. One exception is the business record exception. We're right on top of it. Under the business record exceptions, that would records that would otherwise be hearsay are admissible for their truth, so long as they are regularly kept in the course of the declarant's business and are not made for the purposes of an anticipation of litigation. Here, the invoices are business records kept by the mechanic. The invoice is relevant for the issue where the woman had defective brakes at the time of the accident. Although the invoice was made when the brakes arrived on January 2nd, a day after the accident, it is likely that the lawsuit was filed sometimes afterwards. More importantly, the invoice is identical to similar receipts. See, good job, Matt. The record, therefore, fits under the business record exception because it was a regularly kept record that was not made in anticipation or for the purpose of litigation. Therefore, it's admissible as truth, even though it's hearsay. A writing containing evidence must be authenticated before it's admitted. Authentication can take place in a number of ways, including through comparing and handwriting of signatures. Additional point. Here, the invoice was written and signed by the mechanic. A fact finder or even a lay witness can compare the handwriting or signatures to authenticate the invoices. Thus, the invoice is admissible.
I think like having these subheadings is just kind of a waste of time. Like, you know, it's a conclusion because it says thus it's admissible. You don't have to do like fancy italics, underline conclusion.
For sure.
It takes time.
Whether the doctor's testimony is admissible. The general rule is hearsay forgiven above. One of those statements is the purpose of medical treatment. We did a great job of issue spotting, gentlemen. I would say ladies and gentlemen, but it's all guys today. Those statements are admissible for the truth, but the statements must be specifically those that are made for the treatment and not, for example, those describing fault. Here, the statement is not accusatory, but strictly medical and was given for treatment after the accident. It informs the doctor that the woman, the doctor's patient, suffered from arthritis for the 5 years. Although they did not state the context, it fits a general pattern made for diagnosis. The statement is relevant because the statement was made for that. It's admissible, even though hearsay. Statements made to a medical profession for the purpose of treatment are generally privileged. The holder of the privilege is the patient and can prevent the doctor from testifying. However, the patient may not claim the privilege if the patient puts his or her physical state at issue. Here, the woman is a doctor's patient, so she enjoys doctor-patient confidentiality. However, by asserting a personal injury action, she necessarily puts her physical condition at issue. She thereby has lost the privilege. Thus, the doctor's testimony is admissible.
I checked back, and this does take place in like state A court, but it says state A adopts exactly the federal rules. So I think they should have written that the federal rules don't include doctor-patient privilege. Only some states have it, but other than that, I think it's good.
Excellent. The fourth issue is whether the roommate's testimony is admissible. Generally, evidence of past behavior of character is not admissible to prove that a person acted in accordance with truth, right? However, evidence of habit, ding, 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 is admissible for the proposition that the person acted in accordance with the habit, even if the witness describing the habit was not present on the day of the incident in question. Habit constitutes actions that are so routinely and repeatedly done that they're likely to be done each time. Habit evidence is usually characterized with words like always, constantly, or never. Here, the roommate is testifying to the man's habit of texting. The roommate said that the man never puts down his phone and even said that the man is addicted to texting. In context, this is not a medical diagnosis, but rather testimony to the man's habit of using his phone and texting. That is probative as to the question of whether the man was texting on the day of the incident. The roommate sentence, he even texts while driving, however, may not be habit evidence. The sentence, he even texts while driving, is equivocal to not necessarily say that he always does. It's right, it's not habit. More likely, the word use the word even and says the roommate says the man sometimes while driving. This is not habit evidence, therefore not admissible. Further, it's highly prejudicial because the fact that the man was texting and driving is the woman's main defense. The sentence's probative value may be substantially outweighed by its prejudicial effect. Thus, the first testimony of the roommates is admissible, but the second one is not. We see this second fact pattern is kind of saying the same thing about whether or not he's an expert is going to be the key piece. This one is going to be business record exception. Remember, that's the key piece. This one is going to be about
okay, here they say party opponent, which is what I would have done, but yeah.
An admission by a party opponent is not hearsay. The doctor saying that the woman told her that. Furthermore, for impeachment purposes, right? So it could be a party opponent admission too. Good job, Matt. And then medical diagnosis.
Who would agree there, but like that's just like what it goes to tell you, like it's about the argument that you can make. Oh, this says like it might not be a medical.
It even said prior inconsistent statement. So this is a really long, solid answer. This seems like my type of answer. I write long answers. Testimony, the roommate, whether it's habit or not, and we say that it'll be character evidence, probably the second part of it. So it was really good. We did a really good job identifying a lot of issues. You know, as Matt recognized, some of the answers came right from the questionnaire that we did. So this was really great. Like we said, we're gonna assign essays for this week, and this video will be right up, and we'll be back next weekend to continue. And next weekend, Matt said, is really important because we're doing agencies, partnerships, corporations, and things that are very heavily tested. And we're moving that one of the MPT lectures up. So
yeah, we'll figure out which one.
Yeah, Matt and I are doing the most to make sure that the people who are in this inaugural UBE course are going to be passing scores so that the course can blow up based on your success. So we appreciate everyone for being here.